Assalamualaikum and hi, my name is Fatina Zira. Today I want to present about provide and analyze the summary of the case. The case that has been chosen from our group is between Muhammad Yusuf bin Abdul Hamid and BTS Hotel Siniran Berhad. For the summary of the case, the company operates or manage several hotels and resorts under Berjaya Corporation Berhad Group of companies, among which is the Berjaya Times Square Hotel Kuala Lumpur. The hotel derives its main source of revenue from the company of its room as well as the patron to its food and beverages restaurants. By way, a letter date 10 September 2003, the claimant was offered employment as a Malay chef grade CC with the hotel. By way of a letter date 27 April 2004, the claimant was then confirmed in employment as the Malay chef grade CC with effect from 1 May 2004. The company avers that the claimant held the designation of Malay Chef Grade CC until the claimant's cessation of employment. It is undisputed that the claimant's last drawn salary was 8,171 with a monthly allowance of 200 ringgit. On March 2020, the country has been hit by the COVID-19 pandemic and the Malaysia government has issued directive for movement control. The Berjaya Times Square Hotel Company needs to comply with this directive. Some of the directive issued by the Malaysia government are general travel ban, closure of business apart from those classified essential service, prohibition of large-scale physical gatherings of people, and restriction of entry and exit of all tourists and foreign visitors. Due to MCO's imposition, the hotel business and revenue significantly decreased because it was unable to function at crucial moment. Due to MCO, the company has taken a few steps to address this situation and lessen the group financial burdens. To all members of the Berjaya Corporation Berhad Group of Company, including the company in this case, a memo dated April 2020 has been issued to the company. The corporation will take the following steps starting on May 1, 2020. The first one is a pay reduction and reduction of fixed monthly allowance for employees earning a combined monthly basic pay and allowance of 6,000 or more, and the introduction of unpaid leave. At first, the claimant was agreeing with this austerity, but after a few times the austerity has changed. The claimant was not agreeing due to the reason which is the unpaid leave is continued to 4 months and being replaced with on a mutual separation exercise where it elected to explore a mutual separation with several of the hotel employees. The claimant has proceeded this case to the court, and the company and claimant has through the court process. There is a role of industrial court and burden of proof, law on constructive dismissal, issues court evaluations of evidence and findings, whether the decision to offer the claimant to be placed on unpaid leave justified.
Hi, Assalamualaikum. My name is Irel Marini. So now we talk about the fact and the issue of these cases. On 20 April 2020, the company Berjaya Times Square Sdn Bhd already noticed to the claimant that they had to reduction his salary monthly allowance and also combine the basic salary and allowances together. On 1 May 2020, the company introducing unpaid leave effective starting 1 April until 30 June 2020. The authorities measures applicable to the claimant were reduction basic salary, monthly allowances, and compulsory unpaid leave. However, the claimant had agreed with the notice. After that, in Recovery Movement Control Order (RMCO), the compulsory unpaid leave had to be extended until August. Then, for the month of September 2020, the claimant was paid his full salary. This is because the company sent the claimant to the other's property to get the job, so that the claimant get his full salary. For the month of November, the company notified the claimant to make implementing compulsory unpaid leave of 14 days from 1 November until 30 November 2020, and also reduction of basic salary and allowances. After that, the company notified the claimant that they decide to place the claimant on unpaid leave from 1 December 2020 until 31 March 2021. The claimant did not agree. Because of that, the company retracted the notice. They changed to the claimant by notifying 1 month unpaid leave from 1 December until 31 December. However, the claimant did not agree and unsatisfied. He responded to claiming a constructive dismissal. Before that, the HR of the company, Mr. Ng Shin San, already gave the package to the claimant. They changed the basic salary to 2,500 plus 1 month salary in lieu. But maybe the claimant did not agree. Because of that, the claimant felt unsatisfied and claimant bring this case to the court. The claimant felt that the company was breached the contract in the employment law. On 1 May 2020, the company introducing unpaid leave effective. Starting 1 April until 30 June 2020, the authorities measures applicable to the claimant were reduction basic salary, monthly allowances, and compulsory unpaid leave. However, the claimant had agreed with the notice. After that, in Recovery Movement Control Order (RMCO), the compulsory unpaid leave had to be extended until August. Then, for the month of September 2020, the claimant was paid his full salary. This is because the company sent the claimant to the other's property to get a job, so that the claimant get his full salary. For the month of November, the company notified the claimant to make implementing compulsory unpaid leave of 14 days from 1 November until 30 November 2020, and also reduction of basic salary and allowances. After that, the company notified the claimant that they decide to place the claimant on unpaid leave from 1 December 2020 until 31 March 2021. The claimant did not agree. Because of that, the company retracted the notice. They changed to the claimant by notifying 1 month unpaid leave from 1 December until 31 December. However, the claimant did not agree and unsatisfied. He responded to claiming a constructive dismissal. Before that, the HR of the company, Mr. Ng Shin San, already gave the package to the claimant. They changed the basic salary to 2,500 plus 1 month salary in lieu. But maybe the claimant did not agree. Because of that, the claimant felt unsatisfied and claimant bring this case to the court. The claimant felt that the company was breached the contract in the employment law.
Hi, my name is Nora Ayuni Atira binti Zamruri. I will present the Employment Act. As we know that the employers Malaysian must comply with employment and labour laws when hiring, manage and terminate employees. In this presentation, I will cover 4 laws of Employment Act based on the article that we search. First, I would like to talk about a salary reduction. According to Section 43 of the National Salary Consultative Council Act 2011, an employer who fails to pay its worker without a valid excuse is in effect breaking the law. To help, the Labour Court makes a judgment based on the employee's complaint and determines whether the dismissal is justified. If the court finds that the dismissal was not justified or justified, it will order reinstatement and payment of the outstanding amount. Second is working during MCO. According in Employment Act 1955, Section 4AB, in deciding any appeal made to him, the minister may make such decision or order thereon as appears just, and such decision or order should be final. To help, the Prime Minister said to MCO during COVID-19 to keep the safety and health. This is the reason employees should work from home. Net is to determine whether dismissal or not. According to the Industrial Relations Act 1967, the Labour Court should have decided first.
It was held that with regards to a reference under Section 20 of the Industrial Relations Act 1967, the Industrial Court ought to have first determined whether there was a dismissal or otherwise. And lastly, the claimant had agreed to the foregoing after raised the measure by countersigning the letter of 27 April 2020. The once of proof shift to the company to support the claimant's dismissal only when the claimant has proven all of the aforementioned prerequisites for constructive dismissal in relation to a dismissal under Section 20 of the Industrial Relations Act 1967. However, the claimant will be deemed to have resigned and or abandoned his work if he quits in a situation where these requirements are not met. There won't be a dismissal in the sense of the Industrial Relations Act of 1967 as a result. I think that's the end of my talk today. Thank you for your attention.
Based on the court's evaluation of the evidence and finding, the pros and cons related to the issue of whether the decision to offer the claimant unpaid leave was justified can be summarized as the follow. Before that, I would like to introduce myself, which is my name is Aisyah Shahida binti Abdul Samad. So I will to continue the pros and cons. Okay, first the pros from the company of the perspective. For the first is financial constraints. The evidence presented in court support the company claim that the hotel experienced, which is Hotel BTS, experienced significant financial constraint due to the COVID-19 pandemic and government imposed restriction. Placing the claimant on unpaid leave was a measure taken to manage operational costs and ensure the financial sustainability and the business. Authority measure for the second pros. The court acknowledged that the company was left with no viable alternative but to undertake authority measure, including inviting employees for mutual separation and placing employee or workers for the unpaid leave. Third, reasonable decision. Considering the circumstances surrounding the hotel's BTS business, the court found that the company's decision to offer the claimant unpaid leave was justified. The CMCO and restriction imposed on inter-district travel and tourism activities further justified the need for such measure. Breach of employment contract. The claimant argued that the being placed on the unpaid leave amounted to a breach of his employment contract. From the claimant perspective, the decision may have been seen as unfair for detrimental to his right and financial well-being. Second, for the disadvantage, which is the employee dissatisfaction. The court evaluation of the evidence did not specifically address the claimant's satisfaction or dissatisfaction with the company decision. However, it can be inferred that the decision to offer unpaid leave and the overall implementation of authority measure that can result in the employee dissatisfaction and lower the morale. Last but not least, potential constructive dismissals claim if the court were to find that the company conduct constituted to a fundamental breach of the employee contract, it could have the implication for the claimants, which is a claim of constructive dismissal. The company would need to justify this dismissal, and the claimant refused the mutual separation offer that may be a factor considered in the regardless. Another solution that can use in this case is the claimant has to provide adequate proof that the employer had breached the employment contract if he wants to claim it as constructive dismissal. For example, the claimant has to prove a written notice or communication clearly with the employer about the decision to impose unpaid leave or
the claimant can use the employment contract to make another proof. This is because when an employee breaches in employee's contract, the employee has the right to leave his job and claim that the employer's action amount to the dismissal. The case can also refer to the industrial court for arbitration.